Hi, welcome to the No Group's presentation on our stance that the three-strike laws and get tough policies do not work. This presentation was done by Joshua, Tashawn, Raylyn, Colton, Summer, Wesley, and Emma. So there's a couple key terms that we want to start off with before we jump into the main crux of our argument. The first key term that we want to point out is the 3 strikes and you're out. So this imposes longer prison sentences for certain repeat offenders, as well as it instituted other changes. It requires that a person who is convicted of a felony and who has been previously convicted of one or more violent or serious felonies receives a sentence enhancement. Then we have the second strike offense. If a person has one previous serious or violent felony conviction, the sentence for any new felony conviction is twice the term otherwise required under law for the new conviction. And then we have our third strike offense. So if a person has 2 or more previous violent or serious felony convictions, that any new felony conviction, it can be a life imprisonment with a minimum of 25 years in prison for that third felony. So then we have consecutive sentencing, and this statute requires consecutive rather than concurrent sentencing for multiple offenses committed by strikes. This basically just means if you have 2 different crimes you've committed, instead of saying you have 2 years for each crime, you can get out in 2 years if it's concurrent. If it's consecutive, it means you have to serve 2 years for one crime and then 2 years for the next crime. Then we have unlimited aggregate term, and there is no limit to the number of felonies that can be included in the consecutive sentence. So the more felonies you create, the more they can just stack it on top. Then we have time since prior conviction and it not being considered. So this basically means that the time in between the prior and new felony convictions does not affect the imposition of the new sentence. So essentially serious and violent felony offenses committed many years before a new offense still count as prior strikes. And then probation, suspension, or diversion is prohibited. That means that probation may not be granted for the new felony, nor may imposition of the sentence be suspended for any offense prior to. They must be committed to state prison, and they are not eligible for diversion. And then finally, we have limited good time credits, which means that strikers cannot reduce the time they spend in prison by more than 1/5, which the standard is generally 1/2. So obviously 1/5 is a lot less than that. They cannot reduce that time by earning credits from work or educational activities. So next, we want to kind of go into the history and background of 3 strike laws. So before we had 3 strike laws, New York State had the persistent offender law. While similar to 3 strikes, it varied in that criminals were not limited to 3 strikes, and punishment was based on the judge's professional opinion of the criminal and the case. So there was a lot more leeway. The first 3 strikes law was enforced in Washington State when that law was passed. A year later, California proposed Proposition 184, or the 3 strikes and you're outlaw, as they called it. This law was passed easily with a large amount of California residents voting for it. This was due to the brutal rape and murder of 12-year-old Californian Polly Klaas. She was murdered by Richard Allen Davis, a man who had a very long and disturbing criminal record. Many states followed suit as high-profile murders such as Polly's became more frequent. The rise of violent crime from ex-felons became alarming enough for many states to enact the 3 strikes law along with Washington and California. By 2004, 26 states had implemented the 3 strikes law or a law of similar nature. So there are also some Supreme Court cases that we wanted to cover, a little bit of jurisprudence on this matter that we wanted to talk about. So first, three strike laws constitutionally have been challenged in the case of Ewing v. California, and that was in 2003. Ewing, the petitioner, had committed grand theft after already having previous felony convictions on his record. Because of California's three-strike law, Ewing was facing 25 years to life. Ewing petitioned the court stating that it was a violation of his Eighth Amendment rights. The case made it to the Supreme Court, where it was ruled that California's three-strike law was not in violation of the Eighth Amendment. So obviously that kind of cuts against our overall case, but if you look down below, there was a more recent Supreme Court ruling, Johnson v. United States in 2015, where a similar federal three strikes law, the Armed Career Criminal Act, was actually found to be constitutional. So we understand that the Ewing case, they supported three strike laws, but that was in 2003. Much more recently, in 2015, the courts are starting to find these three strike laws or similar laws to be unconstitutional. And then here's just some more evidence against the support of the three strike laws. So first of all, those who commit nonviolent or misdemeanor crimes can receive a life sentence for those crimes. If you're a nonviolent criminal, it doesn't really make sense that a life sentence should be applied to you. Second, by enacting Get Tough and three strike laws, it can lead to overpopulation in the prison system. Third, the needs of the offender are not met, such as discernment from a judge for proper sentencing. And then, those who are able to afford good lawyers can receive lesser sentences, while someone who is not as fortunate, cannot afford as decent legal counsel, could receive a life sentence for like the exact same crimes, essentially. And then finally, potential life sentencing from the three strike laws can cause some who are charged to fight. It can cause people who are charged, they might want to fight it, and that could result in long, drawn-out, very expensive court cases. And finally, we just wanted to address some counter-arguments that the pro side may have. So the for side argues that three strike laws act as a strong deterrent and can reduce crime. However, studies done by the Centers on Juvenile and Criminal Justice and National Institute of Justice show the contrary. For example, three strike laws led to an overpopulation of the prison system with nonviolent offenders. From 1990 to 2009, the number of Californians aged 40 and up arrested for felonies leapt from 58,000 to nearly double at 111,000. And second, it's not equipped to handle drug epidemics because three strike laws are premised on people acting rationally and thus deterred when the heavy cost outweighs the benefit of the crime. However, most drug users do not act rationally for a myriad of reasons, generally speaking because of their addiction. So three strike laws, for a lot of the cases that are being brought up with them, just aren't as effective as some might claim they are. So, in conclusion, the three strike rule has not proven to deter criminal behavior or repeat offenders. It puts an unnecessary strain on the court system and the prison system with lengthy and expensive trials and sentences, and it just causes a lot of unnecessary overpopulation. Next, some three strike laws have already been struck down by the Supreme Court. We talked about the one from 2015 that was struck down, and so we can see the jurisprudence is kind of changing in that regard. And so overall, these are the reasons why three strike laws and Get Tough laws should not be supported and are not a benefit to American society.